You said it. It is the presumption of innocence. I mean, that's exactly what it means. As in city court, they're bench trials. So the judge is the fact finder. And so you got to go in as the judge knowing that, okay, there's nothing against the defendant right now. Right now, or let's say the trial begins, the prosecutor presents the affidavit charging the defendant. And at that point, without anything else, they're not guilty, period. Okay, because the charging instrument is not evidence of guilt. It's simply the
Exactly.
charging instrument, and you have to, at that point, it's still the presumption of innocence. And then so the prosecution still obviously has to meet their burden of proof beyond a reasonable doubt that the defendant is in fact guilty. And you mentioned it. There have been some judges that in the past that we've both been in front of that perhaps in their mind that proof beyond a reasonable doubt is really just more along the lines of probable cause. Yeah, they probably did it, and I think that's it's obviously unconstitutional, but I think it's completely unfair to the defendant. Proof beyond a reasonable doubt is a very high burden. It's the highest burden we have, and as a judge, I'd make sure that the prosecutor absolutely meets that burden of proof beyond a reasonable doubt before I would find anybody guilty of any infraction or crime.